One of the labels that has been attributed to her and has been written about in most of these stories running this week has been the term quota queen. Where did that come from and what does that mean?
Well, I was told by Clint Bullock that it came from the Wall Street Journal, and you have to ask him about that because it was in an article that he wrote, Clint, a former Reagan Justice Department civil rights official. It is, in my view, something that borders on racism.
Not besides
narrow.
Now wait a minute. Let him finish his answer, Senator Ryan.
And she views that as tokenism and problematic. The problem is her solution. The problem is her solution.
The answers are misleading, with all due respect.
Well, wait a minute. They may be misleading, but they're his answers.
Okay, fine.
Fire away.
Her notion about majority rule, her view about proportionate representation. In order to vote in a corporation, you have to own property. You have to own the property of the corporation. The more voting shares that you own, the more weighted your vote.
With respect, they are my answers, and with respect, they're not misleading, they're accurate.
Well, it used to be that you had to own property to vote in elections, too, in this country. Unfortunately, that's not the rule anymore.
The Supreme Court has been in the news a lot recently, and I can't exactly say it's for anything good. There's, Editor Mitch, just, do the thing. So what's the deal? Are these rogue people just political hacks, or are they, in Chief Justice John Roberts' words, just there to call balls and strikes and not to pitch or bat? Well, to start, neither of these statements are entirely true. Law and politics are inseparable, but that doesn't mean they're the exact same thing. Judges are certainly doing a lot more pitching and batting than Roberts is willing to let on, but that doesn't mean that it's all they're doing. It'd be absurd and outlandish to say that every judicial decision is based solely on the politics of the judge or judges that made the decision. Judges, like everyone else, are humans who make decisions for complicated reasons within the incentive structures they operate. Would you look at that? We're 200 words into the essay, and it's already time to quote Patricia Williams again. That life is complicated is a fact of great analytic importance. What's missing from this conversation is complexity. Not complexity for complexity's sake, but the real and honest complexity of life that we all experience every day. We get that life is complicated because we live that complexity. Despite that, there's a narrative that normal people read as people not in power are incapable of understanding what's actually going on. The result is this endless spewing of tepid oversimplifications that pose politics as some type of logic problem, that upon finding the ideal, optimized solution, that one quick fix, politics will be a solved game. In fact, if you pay attention to the underlying logic of what's being said, you'll see that in their mind, politics is already solved. And I'm not just talking about the increasingly fascistic conservative movement in America. Even supposed leftists, like Vaush, sell politics as a solved game. One just waiting for brilliant minds like his to provide the obvious answers to all the rubes who, don't get it. Something that he, of course, could not do without your generous financial support. As you watch this clip of Vaush discussing why the court overturned Roe v. Wade, pay attention to the way he dismisses a nuanced understanding in favor of his quote-unquote cringe but 100% accurate take.
Look, these people pose an existential threat to all life. And, we need to understand and recognize this. What we're dealing with right now is a combination of political forces, but at the end of the day, we have to recognize where this keeps going back to. This really does always come back to fundamentalist Christianity. There's no way around it, I understand there are lots of people on the left who think it's kind of, cringe to be a Reddit atheist. To be honest with you, I'm going to be straightforward. At this point, I think it's cringe to be anything but a Reddit atheist. I don't know how we can maintain that aesthetic distinction in a time like this. We're getting bled out by fundamentalist Christianity. You go, Reddit atheist. I don't care. You go, whatever. You do your best, okay? Every cringe Reddit atheist who was screaming about how, the Christards are going to destroy America back in 2010 were completely correct, weren't they? They were all completely correct. It seemed naive at the end of the Bush, the beginning of the Obama administration, but they were completely correct, I don't give a shit, dude. You grow a neckbeard, you tip your fedora, you weigh 400. I simply don't care. You were right. You were the hero. You were the prophet.
Yes, of course fundamentalist Christianity is a part of this decision, and it could even be a really big part of the decision, but that doesn't make it a useful answer to the question, let alone the answer to what's going on. What are we supposed to do with this? following Vosh's logic that this decision only happened because of fundamentalist Christianity, the obvious answer is to ban fundamentalist Christians from sitting on the Supreme Court, or otherwise make it unacceptable to be a fundamentalist Christian. Even if banning a religious group from sitting on the court was constitutional, which it isn't, reducing the court's decision to fundamentalist Christianity equals no abortion equals bad does functionally nothing. It produces no coherent theory of political change because marketing politics as solved is inherently conservative. Hell, just listen to Keffels as she explains how she's the real victim when people call her
People aren't
racist.
leftists or reactionaries using leftism as an aesthetic to attack Yeah, it's not politics, it's internet drama. I think it's fucked up, honestly, how bad the video essayist side of the left online is, considering the video essayists have the time to pull back and think about what they want to say before they say it, which is not something that live streamers are afforded, but they still manage to say really fucked up things. And it's worse. It's worse because it's like pure intention, because they have the time to think about what they want to say and they still say terrible fucking things. Whereas, you know, with live streamers, it's like you can just like fuck up what you're saying and then you don't actually mean what you said, but guess what? It's clipped forever and it's going to be held over your head forever, even though the intention behind the words that you have said is not actually there. But no one gives a shit because if they don't like you, that doesn't matter. At this point, making a Debate Bro Bad video about these woke school video essayists is a rite of passage. It guarantees easy views and cements your place in the woke school space. It's unfortunate. Because it's true. It just happens over and over again. And he's also right. Like, it has nothing to do with politics. It's just internet drama. And, like, at least with me, I can own it. I can be like, this isn't politics. It's just internet drama. It's just entertainment. It's here to entertain you and distract you from the fact that the world is fucked up and messy, and you don't always want to think about how fucked up and messy the world is. And I hope that you all appreciate that honesty, because it's like, you're not going to get it from all of these creators.
This isn't politics, it's just internet drama. It's just entertainment here to distract you from a fucked up world. Whether you call it politics or not, these people are engaged in a form of anti-politics that tells you that the most radical political action you can take is to tell everyone else how fucked we are and how everything would be solved if people just did politics the right goddamn way. Don't listen to the woke swole tenderqueers. All they do is make you feel bad. Listen to me and have some fun. This politics doesn't motivate people to vote, to run for office, or even to get involved in their local community. It motivates people to sit at home and harass anyone they deem as unenlightened, with a particular venom for people who are publicly sitting at the intersection of marginalized identities. This is a politics of nihilism. That's precisely why it can never offer a theory of change. To develop any coherent idea of how you can change the world, you have to have hope that things can change. And hope is something more than a list of bad guys that need to be stopped. This isn't a video about Vosh or Keffels, but it is a video about how our conversations around politics, especially those around the Supreme Court, favor progressively coded anti-politics and explicit conservative ideology over working to articulate a meaningful theory of political change. To do this, I'm going to tell you the story of the Voting Rights Act, from the Act's origins to its death at the hands of the current Supreme Court. But we won't end there. In the last section, I'm going to lean on the work of Lani Guinier, the first and for decades only tenured black woman to teach at Harvard Law, to offer an actual theory of political change. I can't stop you from skipping ahead. I mean, I did create timestamps, but I really encourage you to watch the whole thing. But before any of that, hello and welcome to the channel. My name is Mitch. I'm a 23-year-old queer with a law degree. I've got a joke here about owning a frame, but I actually have the paper now. They mailed it to me. If you're new here, though, which is probably most of you, a few reminders. First, I don't know everything, and I'll probably get some things wrong. Second, I'm committed to hearing where I went wrong and doing the work to learn from my mistakes. Third, I hope you're willing to be a bit vulnerable and do the same. And to the 30 or so of you who have been here before, welcome back. I am so glad you chose to stick around. And with that out of the way, let's get right into it. In the United States, there is no right to vote, at least not one explicitly written anywhere in the Constitution. Trust me, I've read the textbooks, I've taken the classes. Hell, one of the guys who wrote this book hooded me. That sounds even worse aloud. It's an academia thing. Look, there's a photo, now we can move on. The point is, you could pause the video right now and read the Constitution. I don't know why you would, but the closest thing you'll find are the 15th Amendment, the 19th Amendment, the 24th Amendment, and the 26th Amendment. All of those amendments expanded the right to vote, but the weird thing is, none of them affirmatively grant a right to vote. Instead, what they do is state that the right to vote cannot be denied or abridged. This is an important distinction. I've said legalese, and that means I'm going to have to explain what the highlighted word somewhere on the screen says before we go any further in the video. They're normally law school words, and it's really annoying. So, distinction refers to the legal idea of distinguishing, which is the process of noting relevant differences between facts and or law at issue in a legal case. It's basically shorthand for saying these things are different and it matters. So what I'm saying is it's important that these amendments don't say, quote, women have the right to vote, end quote. And what they do say is that, quote, right to vote shall not be denied or abridged based on sex, end quote. One of those affirmatively grants a right, and the other one only says that the right cannot be denied. This might be less important if the Constitution explicitly granted the right to vote anywhere in the document, but that wasn't what the dudes in wigs gave us. What we have is a set of amendments that say, quote, the right to vote exists somewhere in the Constitution, and that you can't discriminate based on certain things. This quirk is no accident. It is a fundamental part of how the powerful designed the system.
Of the vote have faced resistance from the beginning. When America declared independence, New Jersey decided to let anyone with enough wealth vote.
There were women who were widows. There were free African Americans in New Jersey who said, I own property, I'm gonna vote. And they did.
But then came concerns about voter fraud, men cross-dressing to vote, ineligible women voting by the carriage full. After 30 years, New Jersey politicians stripped women and black men of the right to vote, groups that also happened to be voting against them. Non-citizens could vote almost everywhere in early America, but over the decades, states took that right away too. And when the federal government began to extend the right to vote to black men in 1867,
the very next year, Florida passed a law that said those with a felony conviction could not vote.
The 15th Amendment banned states from restricting the right to vote on account of race. It doesn't say anything about getting arrested.
What's also happening at this time, a rise of laws coming out of these states that criminalize blackness, laws that only black people are subjected to.
And it wasn't just Florida. Felony disenfranchisement laws had spread all around the country. White Democrats throughout the South enacted a patchwork of other laws designed to restrict the vote so they could hold on to power.
They did it by using the legacies of slavery, the legacies of the lack of wealth.
Like taxes you had to pay to vote, with exemptions if your grandfather voted.
Well, if you were a slave, this is the first generation after slavery, no one's grandfather, if you were black, would have been permitted to vote.
The legacies of the lack of access to education.
Like understanding clauses and literacy tests.
The man who helped raise me talked about taking the literacy test. And his question was, how high is up? Yeah.
Those actually originated in the Northeast, and they targeted European immigrants who came from non-English speaking countries. And so over and over again, we've seen voter suppression target communities. Sometimes it's racially based, but always it's because those in power do not want to share that power.
The list went on.
And whatever those policies didn't cover, we experienced state-sanctioned violence.
Voter suppression has existed in almost every state in our nation.
Voting hasn't always been a right. It's often been described as a privilege. Even today, if you talk to conservatives for long enough, you'll likely hear them say that voting should be a privilege. Or if they're a bit savvier, it may sound like this.
You do have to ask yourself, if someone doesn't really care enough to go down to the school gymnasium and cast a ballot, how eager should we be to get that person's vote?
Fuck this dude. There are all kinds of reasons people can't go to their local gymnasium, and that's completely ignoring the fact that local polling locations are not that convenient for... Look, I need to save this energy for later in the video, not this dude. Even with the supposed guarantees and protections of these amendments, the right to vote has always been contested imperfect, and too frequently non-existent. Despite that, voting has always been recognized as an important but limited tool for creating material and political change. The Voting Rights Act is intrinsically linked to the civil rights movement. The inconsistent progress and failures of Reconstruction served as the living and present context for the civil rights movement. For many, slavery was a mere generation away. As I said in my last video, this period and the amendments that come from it are extraordinarily important and incredibly relevant to our current politics. If you want more on this, go watch that, and I'll have a whole video on these amendments maybe someday. Back to the topic at hand, the Voting Rights Act was introduced in 1965, just 8 days after the Bloody Sunday March in Selma, Alabama. This was no accident. The marches in Selma to Montgomery were part of a broader, months-long campaign to advocate for voting rights in Dallas County, Alabama. Dallas County was fertile ground for this type of action. In 1960, Dallas County had a voting age population of approximately 30,000 people. Approximately 15,000, or half of that, was black. Despite these statistics, the 15th Amendment's supposed protections against racial discrimination, less than 1% of eligible black residents were able to successfully register to vote. The campaign was started at the suggestion of local activists and was led by the Southern Christian Leadership Conference, the SCLC, which was led by Dr. Martin Luther King Jr., an anti-capitalist activist who was actively surveilled by the FBI for his political activity and assassinated for his beliefs. The campaign originally started as a voter registration drive, where protesters took the radical step of registering to vote while black. For the racist pro-segregation sheriff and their deputies, this was an invitation for unrepentant violence. Throughout January and February of 1965, the number of imprisoned black people grew to exceed the number of registered black voters. On February 18th, a night march in the nearby Marion, Alabama was met with racialized violence. On this night, an Alabama state trooper shot and killed local voting rights activist Jimmy Lee Jackson as he tried to defend his mother from being beat by state troopers. Jackson's death inspired James Bevel, the SCLC's Director of Direct Action and Nonviolent Education, to organize a march from Selma to Montgomery to honor Jackson. Over the next few weeks, Bevel's ideas grew into a set of coordinated actions and protests aimed at combating voting rights abuses. On Sunday, March 7, 1965, the table was set and the march from Selma to Montgomery began.
On Sunday, March 7th, some 600 individuals set off from Selma's Brown Chapel AME Church and began walking toward Montgomery. The demonstrators took a route across the Edmund Pettus Bridge, spanning the Alabama River. When they reached the opposite bank, Alabama state troopers blocked the road, refusing to let them pass.
To be detrimental to your safety to continue this march, and I'm saying that this is an unlawful assembly, this march will not continue. Troopers here advance toward the group.
You saw these men putting on their gas masks. And behind the state troopers, a group of men, part of the sheriff posse, on horses. They came toward us, beating us with nightsticks, trampling us with horses, and releasing to take us. I was hit in the head by a state trooper with a nightstick. My legs went from under me. I don't know how I made it back across the bridge, but apparently the group just literally took me back.
John Lewis suffered a fractured skull. Including Lewis, 17 marchers were hospitalized, and roughly 100 wounded in all. That evening, network news channels broadcast footage of what came to be known as Bloody Sunday.
The televised brutality galvanized the nation, and more importantly, Congress, in support of national action to address voting rights.
There is no moral issue. It is wrong, deadly wrong, to deny any of your fellow Americans the right to vote in this country. But really, it's all of us who must overcome the crippling legacy of bigotry and injustice. and we shall overcome.
The way this story is normally told, this is the end. Congress passed the Voting Rights Act just 4 months after the March from Selma to Montgomery. That's incredibly fast for anything Congress does. And the law solved all of the problems. Any issues that might still exist, like, racist voting practices, are just an issue of courts and lawyers working in good faith to find the correct interpretation of the law. You might sense a bit of a theme here, but I really don't like when institutions tell us to take their word at face value. So let's dig deeper. What were the goals of the Civil Rights Movement? What were the goals of the Voting Rights Act? Are those two things even the same thing? Have we achieved either of those sets of goals? Lani Guinier argues that the goals of the Civil Rights Movement and the Voting Rights Act are fundamentally different. While the Civil Rights Movement advocated for transformative political and economic change, the Voting Rights Act merely set black electoral success as its end goal. Similarly to the way the constitutional amendments assume that there is a right to vote in the Constitution, the Voting Rights Act relied on a set of assumptions that presumed that electing black officials would in and of itself lead to transformative political and economic change. Guinier terms this the theory of black electoral success. In black electoral success theory, empowerment is obtained through meaningful enfranchisement, which exists where blacks are elected. The theory thus promotes the election of individual black representatives as spokesmodels for political equality. Simply by virtue of election opportunities, black electoral success advances civil rights enforcement, government intervention on behalf of the poor, and the black role model development. How did this theory emerge from the civil rights movement? Guinier identifies the shift from protest to politics and the need to bridge divisions between the nationalist and integrationist wings of the movement as critical for why the black electoral success theory emerged. The act both committed to the black community collective action in pursuit of political power and camouflaged the tension between assimilation and recognition of racial group identity and interests. Despite doing the lowercase l liberal thing of trying to reform the system and make it better through the mainstream notion of voting, these voting rights activists fought to expand politics to include a redistributive vision premised on equality of inclusion, not merely freedom from overt discrimination. The goal of this movement was not simply to elect black officials, it was aimed to expand our rights to affirmatively include the freedom from hunger, poverty, and discrimination. As Guinier notes, participation in the dominant political system did not necessarily mean assimilating its substantive assumptions or power arrangements. For many radicals, voting was nonetheless seen as a useful, if limited, tool for advancing your political goals. Struggling to find a unifying theory of political change, the integrationist and nationalist wings of the civil rights movement each came to the black electoral success theory. For integrationists, this fit perfectly into their liberal sensibilities that a political system is fair only if the process seems fair, regardless of the actual results. Whereas the nationalists supported the black electoral success strategy because they viewed it as a method of achieving group recognition and internal group solidarity. Guinier distills the black electoral success theory down to 4 assumptions. I'm going to put explanations on the screen as we go. First, black officials were authentic representatives because of their inherent connections to the black community and culture. Second, black officials gained authority from the fact that they were elected. Third, black officials were legitimate because they inspired community mobilization and enthusiasm. And 4, black officials were presumptively responsive to black voters, with strong and cohesive civil rights, redistributive, and community-based agendas. Taken together, these assumptions posit that black officials are always authentic, legitimate, and responsive representatives of the black community who are building political power for the black community by simply being black and being elected. That is Guinier's theory of black electoral success in a nutshell. Now, let's take a look at how this theory was incorporated into the Voting Rights Act. The Voting Rights Act did a lot of things. It's considered by most scholars to be the most influential civil rights law ever enacted in the United States. I could explain the entire Voting Rights Act, but that's more billable hours This legal research does not do itself. So until you figure out who's paying me, this is all you're getting, and it's a summary. So, the Voting Rights Act was enacted to enforce the 15th Amendment's protections against denying or abridging the right to vote based on race. Here's the text of the 15th Amendment, and if you look at Section 2, you might remember what I said in a similar part of the last video about the 13th Amendment. If you remember Section 2 of the 13th Amendment, so I know, big ask, Congress shall have the power to enforce this article by appropriate legislation. In law school, that one sentence is a big deal. See, this sentence, getting back to the Congress part of it, was added to the Constitution, and it told Congress, do what you need to do. That is an incredible grant of power. Important aspects of this included sending federal registrars to register voters in the South and outright banning poll tests. But far and away, the most prominent and long-lasting enforcement mechanisms were Sections 2 and 5. The original 1965 text of Section 2 is fairly straightforward. No voting qualifications or prerequisite to voting or standard practice or procedure shall be imposed or applied by any state or political subdivision to deny or abridge the right of any citizen of the United States to vote on account of race or color. So, any laws or regulations that deny or abridge the right to vote on account of race are illegal. That's it. Sometimes you just need to pass a law that says racism is illegal. But the people who passed the Voting Rights Act knew that saying racism was illegal wouldn't be enough. That's where Section 5 comes in. Section 5, in conjunction with the formula in Section 4, established a system of federal pre-clearance for states with a history of discriminatory voting practices. This included states that used literacy tests and states that had less than 50% of eligible voters participating in the 1964 presidential election. In these states and political subdivisions, any change in voting laws or regulations could not be enforced without approval by the United States District Court for the District of Columbia or the Department of Justice. In order to get approval, the state must prove that their proposed voting change does not violate the other provisions of the Voting Rights Act, namely Section 2. And that's the Voting Rights Act. At least that's the Voting Rights Act bipartisan Congresses repeatedly renewed over the course of 4 decades.
Every time the Voting Rights Act was set to expire, the government reauthorized it.
As long as I'm in a position to uphold the Constitution, no barrier will come between our citizens and the voting booth.
By reauthorizing this act, Congress has reaffirmed its belief that all men are created equal.
I like that clip, but politics is never going to be as simple as what Leonardo DiCaprio says in a Netflix documentary. From the beginning, motivated lawyers, interested clients, and wealthy benefactors have had it out for the Voting Rights Act. Despite the regular bipartisan glitz and glamour of reauthorizing the VRA, conservative activists have long understood that it is entirely possible to achieve your political goals without passing, or in this case repealing, a law. The trick is knowing who to ask. Just 1 year after the Voting Rights Act was passed, the Supreme Court heard a direct challenge to the law's constitutionality. In South Carolina v. Katzenbach, an 8-1 court soundly rejected the challenge and held that the 15th Amendment gave Congress full remedial powers to prevent racially discriminatory voting, and that the Voting Rights Act was a legitimate response. That full remedial powers bit is a big fucking deal. If you are doing law the way you're taught in law school, this case requires you to give the Voting Rights Act similar authority and deference. In the legal world, deference refers to how much a court is going to trust another authority on the law. When a court is highly deferential, they are likely to trust that the law is a legitimate exercise of power. On the other hand, if a court is not deferential, they'll be suspicious of a law's legality. Because the Voting Rights Act is a direct exercise of the remedial powers explicitly granted in the 15th Amendment. This is literally the most authority a statute can have without itself being a constitutional amendment. But as we all know, racists are going to try and be racist regardless of whether it's illegal. That's what lawyers are here for. They get paid to read the law and find creative ways to explain how those words that say X really means Y. That's how we got to City of Mobile v. Bolden in 1980. The issue in this case was whether or not the City of Mobile's at-large municipal election system was diluting the power of minority voters. I don't know how elections work around where you live, so I'll take a moment to explain at-large elections and why I agree with the people bringing the suit. So imagine your city is going to elect its city council. There are all kinds of ways we could decide who should be on the city council, but for simplicity's sake, let's stick to familiar examples. The first is single-member districts, the same method that we use to elect members of Congress. There are set geographic areas with relatively proportional populations. We can call those districts, and they get represented by a single elected official. The second method is an at-large election. In an at-large election, at least the one involved in Bolden, what happens is it's basically any other election, with the primary difference being that all of the candidates run in the same district. So still first past the post elections. The petitioner's argument here was that at-large election system would only ever elect white candidates because white people were the majority of voters and could elect the candidates of their choice without regard to any non-white people. Think about a city that's 60% white and 40% non-white. There are 10 city council seats up for election, and all you have to do to earn a seat is be one of the top 10 vote getters. In an at-large election, white candidates could win all 10 seats without needing to secure a single non-white vote. Meanwhile, non-white candidates can only win with the support of white voters. If the same city used single-member districts, non-white candidates could elect 4 candidates, a big increase from 0. Now, there are some caveats to this. First, this analysis assumes the use of first-past-the-post elections. That's also what you would call the elections where you simply need to get most of the votes to win, not a majority of votes to win, only most. Second, it assumes that racially polarized voting exists, and, well, it's been a yes in America. And third, it assumes a certain level of geographic segregation, which, again, we're in America, so that box is ticked. So here, I think the plaintiffs are right. An at-large election system is racially discriminatory, and it dilutes minority voters' ability to elect candidates of their choice. Does the plaintiff's framing of the issue as limiting the ability of minority voters to elect the candidates of their choice sound familiar? Don't worry, if it doesn't, I'll connect the dots a bit later. This should be a pretty clear-cut violation of the Voting Rights Act and the 15th Amendment, especially considering the evidence that the at-large election system was adopted with the intent to dilute the voting power of non-white voters. After all, they had the other election system beforehand. But for the Bolden Supreme Court, Section 2 of the Voting Rights Act, and by extension the 15th Amendment, only prohibited intentional racial discrimination. To the court, there was no problem whatsoever with a law that had racially discriminatory impacts, so long as racial discrimination was not the explicit purpose. According to the court in Bolden, the city of Mobile didn't mean to discriminate against non-white voters. It just so happened that they chose a method of election that made it practically impossible for non-white candidates to win. After all, they didn't say you can't elect non-white candidates. This is racist bullshit, and these dudes are just making up stuff about the 15th Amendment, if we're being honest. And that's not some modern lefty take. 3 justices saw the con for what it was, and so did Congress. Let's start with the court's internal dissent to Bolden, best encapsulated by Justice Thurgood Marshall's dissent. Marshall, the court's first black justice, had this to say: like outright racial hostility, selective racial indifference reflects a belief that the concerns of the minority are not worthy of the same degree of attention paid to problems perceived by whites. When an interest as fundamental as voting is diminished along racial lines, a requirement that discriminatory purpose must be proved should be satisfied by showing that official action was produced by this type of pervasive bias. In the present cases, the plaintiffs presented strong evidence of such bias. They showed that Mobile officials historically discriminated against black people, and that there are pervasive present effects of this past discrimination, in that officials have not been responsive to the needs of the minority community. It takes only the smallest of inferential leaps to conclude that decisions to maintain multi-member districting have obvious discriminatory effects, represent, at very least, selective racial empathy and indifference resulting in the frustration of minority desires, the stigmatization of the minority as second-class citizens, and the perpetuation of inhumanity. These ideas and arguments over how we define discrimination aren't new. Questions of who can participate and how easy that participation should be have been and always will be at the center of politics. For their part, Congress got to work amending the Voting Rights Act. In 1982, despite strong opposition from the Reagan administration and the newly founded yet already influential Federalist Society, Congress overrode Bolton and amended Section 2 of the Voting Rights Act to read as follows. This explicitly created a results test, meaning practices or procedures that resulted in racial discrimination were just as illegal as those that were implemented with the intent to discriminate. It seems impossible today, but Congress actually said you can be racist without explicitly intending to be racist. It's hard to get white leftists to agree about that today, but apparently the 1982 Congress was cool with it. And it's not like they didn't know what was in the amendments. As I said before, the Reagan administration strongly opposed the inclusion of a results-based test in Section 2. A January 26, 1982 memo titled Talking Points for White House Meeting on Voting Rights Act included this talking point. Quote, an effects test for Section 2 could also lead to a quota system in electoral politics, as the president himself recognized. The so-called savings clause in the House bill would not remove this danger. Just as we oppose quotas in employment and education, so too we oppose them in elections. End quote. That's just the Department of Justice, the supposedly independent federal prosecutors talking with the White House about coordinating their false and racist political talking points. I think most of my viewers will understand the racism, but talk of racial quotas is a dog whistle that spreads the racist lie that non-white people have only obtained their status in life because of race-based advantages unavailable to white people. That talking point is false, not only because of the racism, but because the amendment's savings clause explicitly said that the Voting Rights Act did not establish a right to proportional representation, or a quota. Again, we have people just making things up about the Voting Rights Act and lying about what might happen if you enforce the law as it's written. The good news is, Reagan lost this fight, and the 1982 amendments to the Voting Rights Act included the effects test. The next real question was whether or not the Supreme Court would accept Congress's assertion of what the Voting Rights Act protected. Good legal analysis would uphold the effects test. After all, in Katzenbach, the Supreme Court found the Voting Rights Act to be a direct exercise of Congress's constitutional authority to enforce the 15th Amendment by, quote, appropriate legislation, end quote. Basically, that's a blank check to Congress signed by the Constitution. You don't get a lot of those in America. In 1986, the court had its chance to weigh in on Section 2 in Thornburg v. Gingles, another challenge to multi-member districts based on their discriminatory effects. The court unanimously found violation of the amended Section 2 based on those effects. Though only 5 justices agreed on the precise reasoning, this case reaffirmed the constitutionality of the effects test and solidified the Gingles factors as the legal standard for providing a Section 2 violation. Thing is, sunshine and rainbows can't last forever. And in 2013, the Supreme Court took a look around and said, you know, it's been 30 years since we tried fucking with the Voting Rights Act, and I think it's time to try again. That's where Shelby County came in. In 2013, Shelby County, Alabama was covered by Section 5 of the Voting Rights Act. To rehash, that's the part of the VRA that requires governments with a history of racial discrimination, like Shelby County, Alabama, to get pre-clearance or approval from the Department of Justice or the DC District Court before they can change any of their voting regulations, practices, or procedures. In their legal argument, Shelby County shot for the fences and claimed that Sections 4 and 5 of the Voting Rights Act were facially unconstitutional. That is, they are completely illegal and unconstitutional today, and have always been completely illegal and unconstitutional. How so? According to Shelby County, the Voting Rights Act simply goes beyond what the 14th and 15th Amendments allow. What do those amendments allow? I can't tell you. Shelby County never said. Shelby County also argued that preclearance violated the 10th Amendment. Somebody put that on the screen. Because the Constitution didn't specifically say that you could enact the Voting Rights Act. That's not how that works, but... So their argument is that the entire federal Constitution and the federal court system, including the Supreme Court, have been enforcing an unconstitutional law for 30 years now, and Shelby County is the hero we all needed to finally point it out, save the day from this terrible but easy to miss error. It's a pretty terrible argument. Courts don't like to be wrong, and especially not when lawyers make asinine arguments like the 14th and 15th Amendments are unconstitutional. And credit where credit is due, the District Court and Court of Appeals both soundly rejected Shelby County's argument. Unfortunately, the conservative Supreme Court majority disagreed. You might recognize some of these faces. The Supreme Court ruled in favor of Shelby County and struck down Section 4 of the Voting Rights Act as unconstitutional. Despite winning the case, none of Shelby County's legal arguments were actually endorsed by the court. You see, like I said before, Shelby County's legal arguments are pretty fucking stupid. If a lawyer does any level of good faith legal analysis, they will quickly realize that Shelby County's argument that the Voting Rights Act is and has been unconstitutional is completely mooted by the existence of South Carolina v. Katzenbach, the case where the court literally said that Section 5 was constitutional. The justices aren't stupid. They knew this was a stupid argument. It basically amounted to Shelby County asking for the court to rewrite the Voting Rights Act. But that doesn't mean they didn't want to do it anyways. That's why Chief Justice John Roberts' opinion creates its own legal theory for why parts of the Voting Rights Act are unconstitutional, while pretending that Shelby County was the one that raised these theories in the first place. Courts aren't supposed to do this. Judges aren't supposed to workshop one side's lackluster legal argument into a winning one. As John Roberts said in his confirmation hearing, quote, "I will be open to the considered views of my colleagues on the bench, and I will decide every case based on the record, according to the rule of law, without fear or favor, to the best of my ability, and I will remember that it's my job to call balls and strikes, and not to pitch the bat." End quote. Well, in Shelby County, Roberts sure did a lot of pitching and batting. In a 5-4 majority led by the Chief Justice, the court ended the Voting Rights Act's preclearance regime. According to the majority, when Congress reviewed the Voting Rights Act in 2006, they actually violated the Constitution because the preclearance formula they approved exceeded the authority of the 15th Amendment. Did Congress change the preclearance formula at all? I mean, preclearance and Section 4 have been around and upheld by the court since 1965, so Congress must have had to change something for it to suddenly become illegal in 2013. Well, they didn't change anything, and that's exactly the problem, according to John Roberts. Reinterpreting history, Roberts claims that the remedies provided in the Voting Rights Act were merely meant to be temporary, because the statute itself had a baked-in expiration date. This time limit means that just preclearance itself is not justified, and you really need to prove that it's justified. How do you do that? You prove that discrimination exists on a pervasive scale. Again, how? Well, Congress would have to, reauthorize the bill, right? And they did that, so it's fine. Well, not according to John Roberts in the court. Congress reauthorizing those provisions is just rubber stamping things, and it's honestly discriminating against the South, according to John Roberts. And yeah, you heard that right. The real victims are not the voters who can't vote, but the southern states who have to comply with the Voting Rights Act. they're being discriminated against. Simply reauthorizing Section 4 and the coverage formula, not changing it, is subjecting those states to discrimination, according to John Roberts. So what rights did these states have violated? Out of constitutional ether, John Roberts grabs the 10th Amendment and Article 4 and tosses them into his magical bag, shakes it up, and pulls something out. And what we get is equal sovereignty under the law. What the fuck does that mean, John? Well, Justice Roberts says that the 10th Amendment, and of course the founders' intent, clearly show that every state is supposed to have the same authority over their laws as any other state. And so the Voting Rights Act requiring some states to submit their proposed changes to voting laws to the Department of Justice clearly violates this right, because not all states have the same sovereignty anymore. But preclearance was legal for 50 years, right? Yep. So why is it illegal now? According to the court, the Voting Rights Act already solved racism in voting, which thereby eliminates the whole reason for preclearance to exist. So it's legal. What they're saying is Section 4 of the Voting Rights Act is unconstitutional because the Voting Rights Act worked by getting more black people voting and elected to office. So unless racism is as bad as it was in 1965, before the Voting Rights Act, the court sees no reason for the Voting Rights Act to be in effect, at least as far as preclearance is concerned. Sure, discrimination still exists today, but is it as bad as 1965? Justice Ginsburg's dissent accurately summed up this logic as throwing away your umbrella in a rainstorm because you're not getting wet. But Roberts has an answer to this. Well, at least an indirect one. Roberts points to Section 2 of the Voting Rights Act and says, see, if you are discriminated against, you can still sue under that part of the Voting Rights Act. And this court would have nothing to say about it. To really kill the umbrella analogy, it's like he's saying, look, it's not raining that much, so you can't have an umbrella anymore. And it'll even be nice and let you sue the rain if you get wet. I think I'd rather have the umbrella. It wouldn't be long until Section 2 had its day in court. In 2016, just 3 years after Shelby County, the Arizona Democratic Party sued the state of Arizona, a state that had previously been covered by the Voting Rights Act's preclearance regime, for implementing voting practices and procedures that had racially discriminatory impacts on the state's tribal, Latino, and Black citizens' ability to vote, thereby violating Section 2 of the Voting Rights Act. They also alleged that these changes to the law were made with a discriminatory intent and introduced evidence of explicit racialized campaign appeals from the Republican legislators that passed these laws. By 2021, Brnovich v. DNC had made it all the way to the newly constituted 6-3 Republican supermajority on the Supreme Court. Writing for the court, Justice Alito explained that Section 2 of the Voting Rights Act needed clarification. The last time the court dealt with Section 2 was way back in 1985, when they decided Gingles. The court had previously referred to Gingles as their seminal Section 2 case, but now, according to Alito, Gingles is inapplicable because it only applied to vote dilution claims and not vote denial claims. Vote dilution alleges that your vote matters less than another voter's, where vote denial alleges that your actual ability to cast your vote is restricted. For the conservatives, this distinction is enough for a difference to justify inventing an entirely new interpretation of the law that means something different. I would argue that this is wrong and bad, and really not a good way to do law, especially considering that Section 2 applies to, quote, any practice or procedure, end quote, and makes no distinction between vote denial and vote dilution claims. But even if they're right, the new interpretation of Section 2 was somehow necessary, the majority's opinion in Brnovich is a logically and legally inconsistent mess that seems to clarify Section 2 out of existence. There is so much that I can say about this case. In fact, I wrote one of the first deep dive articles on Brnovich when it was decided in 2021, and I was invited to present it at the 2023 Southern Political Science Association's Election Science Conference. And you can read all 28 pages of it linked below, But this video isn't about Brnovich. Despite that, I can't separate the fact that I've been thinking about this video since I was writing that article in 2021. It's hard for me to separate them because Brnovich is the perfect microcosm of the way the law disregards the complexity of life by imagining its own breed of narrower, simpler, but hypnotically powerful rhetorical truths. To keep myself on track, I'm only going to give myself 5 minutes to explain this case. If you'd like a much longer and thorough analysis of Brnovich, you know where to find it. Essentially, Brnovich reset the standard for a Section 2 violation to intentional discrimination. That's the same standard the court came up with in Mobile v. Bolden, and the same standard that Congress explicitly overrode with the 1982 amendments to the Voting Rights Act. Congress literally said, the results standard is meant to restore the pre-Mobile standard, which governed cases challenging election systems or practices. Of course, the court never explicitly says this. Instead, what the court and the conservative supermajority do in Brnovich is come up with a 100% neutral 5-factor test that just so happens to essentially require intentional and explicit racial discrimination to win under. I'm going to run through these 5 factors twice. On the first go through, I'm going to explain the court's logic. On the second round, I'm going to give my critique and explain why these factors are bullshit. Ready? Let's go. First, the size of the burden imposed. What the court is saying here is that every voting regulation imposes some burden on voters. So for that burden to violate Section 2, it has to be more than the usual burdens of voting. For the court, mere inconvenience cannot be enough to demonstrate a violation of Section 2. Second, whether similar regulations were widespread in 1982 or are presently. Again, relying on the fact that all laws impose some burden on voting, the court reasons that voting rules in widespread use in 1982, the year Congress amended Section 2 of the Voting Rights Act, are presumptively valid and should be seen as a benchmark for acceptable regulations. Number 3, the size of any disparities in impact. Section 2 of the Voting Rights Act prohibits any voting standard that results in a denial or abridgment of the right to vote on account of race. But according to the court, that doesn't mean any denial or abridgment of the right to vote. As Alito explains, quote, to the extent that minority and non-minority groups differ with respect to employment, wealth, and education, even neutral regulations, no matter how crafted, may well result in predictable disparities in rates of voting and non-compliance with voting rules, end quote. So even though these laws say that disparate impact is illegal, what it's really saying is that big disparate impact is illegal, but little disparate impact is okay. How big is enough? Alito doesn't say, but what he does warn of is the risk of artificially magnifying what are at bottom very small differences. Number 4, the opportunities provided by the entire system of voting. Here, the court says it's not fair to simply consider the allegedly discriminatory voting rule. Instead, you need to consider all of the available methods of voting in the state. So, while a tribal citizen may need to drive 3+ hours to return their ballot, the fact that they have more than a week to return it negates that burden. And finally, number 5, any state interest served by the regulation. Importantly, the court claims that, quote, one strong and entirely legitimate state interest is the prevention of fraud, end quote. For the majority, this state interest was justified by the unlikely occurrence of fraud, altering an election's outcome, and by the risk of fraud undermining public confidence in elections and the perceived legitimacy of the results. Further, the court held that it should go without saying that a state may take action to prevent election fraud without waiting for it to occur and be detected within its own borders. For the conservative supermajority, voter fraud is a strong and entirely legitimate state interest that doesn't require even a de minimis evidentiary justification. That is, you don't have to prove it, just say it happens, and that's good enough. There are very few, if any, other state interests that the Supreme Court accepts at face value without evidence like that. Alright, that's the court's logic. But even if I'm being as generous as possible, the majority's opinion makes absolutely zero sense. And that's the point. The law doesn't have to make sense. It doesn't have to be true because it can create its own rhetorical truth. This 5-factor test functions as a lens for the court to filter reality through. The way the court wants you to see it is like they're Harrison Ford in Raiders of the Lost Ark, merely holding up the staff of Ra and allowing the light of God to reveal the capital T truth. But God didn't make the staff of Ra or that model, and God certainly didn't write the Constitution, the Voting Rights Act, or this opinion. Humans did all of that. The court wants to look like a passive actor, just like Harrison Ford. All they're doing is holding up the lens and seeing where the light shines. Except they're the ones that built the lens and the model. They decide what facts are and what factors should or shouldn't be considered. Any lawyer worth their salt will tell you that this matters. So how does the framing in Brnovich change the results? Like I said before, these 5 factors essentially raise the standard for a Section 2 violation back to intentional discrimination. The court does this by setting a high burden of proof for plaintiffs to prove a law is discriminatory, while simultaneously setting an extremely low burden of proof for the governments implementing these laws. The size of the burden imposed and the size of the disparate impact are indefinite standards where the court provided no information as to what a sufficient claim would entail. Instead, the court simply claimed that because disparate impact and burdens on voting are unavoidable, something more is required to violate Section 2. Compounding the difficulties of litigating indefinite standards, the other factors outlined by the court provide states multiple near-guaranteed ways of winning in a Section 2 claim. First, the presumptive validity of voting practices and procedures common in 1982 essentially gives states a win by default if a common practice from 1982 is challenged. Second, states can prevail in most Section 2 cases by simply providing an alternative method of voting that is equally open. Finally, states can prevail in practically any Section 2 case so long as they invoke the strong and entirely legitimate state interest of preventing voter fraud. Because no proof whatsoever is required to invoke the interest of voter fraud, all you have to do is say the magic words, voter fraud, and you win. The overarching message from Brnovich and Shelby is that discrimination in voting is only illegal when it is as explicit and as egregious as it was in 1965. I feel like I don't need to explain why this is problematic to only recognize intentional discrimination, particularly when the laws outlaws discriminatory results. But if you want to hear me talk about that more, you can watch my last video. Up until a few weeks ago, this was the end of the story. The Voting Rights Act had been killed in all but name, and it seemed unclear if the Supreme Court was going to allow any lawsuit under the Voting Rights Act to succeed. But have no fear, here comes Justice John Roberts with another Voting Rights Act decision. No, but this time the New York Times is saying he's here to help. Even Slate's Mark Joseph Stern has a rather glowing write-up of the court's decision in Allen v. Milligan. So what's going on here? Did John actually save the Voting Rights Act? Allen v. Milligan is a case out of Alabama challenging the state's decision to eliminate one of Alabama's 2 majority black congressional districts. Despite black Alabamians making up 1/3 of the state population, the gerrymandered majority white state legislature only cared to draw 1 majority black district to their 6 majority white districts. This is plainly illegal conduct under the Voting Rights Act. First off, under preclearance, this redistricting plan would fail the anti-retrogression principle. That is to say, any law that would diminish the electoral power of minority voters in a covered jurisdiction is illegal. Technically speaking, there are no covered jurisdictions today, so this isn't going to stop Alabama. Thank you, John. But the good news is what Alabama did is also clearly illegal under Section 2. Section 2 prohibits voting rules with racially discriminatory effects, and yeah, getting rid of half the black congresspeople is a racially discriminatory effect. If you're thinking, this seems pretty straightforward, I want to ask you to hold on to your judgment until you hear Alabama's argument. Alabama argued that it's actually illegal to use race as a factor when drawing majority-minority districts. That's not a coherent position. And when Alabama first tried to take this case to the lower federal courts, they completely rejected their claim. And that's because Alabama, following our nation's history and tradition, is just making shit up about the Voting Rights Act and claiming it's the law. This would normally be the end of the line for Alabama. They made an off-the-wall argument and it was soundly rejected by the federal courts. But things are never that simple with this version of the Supreme Court. And for some reason, the court decided that they needed to step in and halt the lower court's orders. This 5-4 order from the Supreme Court required Alabama to conduct their 2022 elections using the map the lower courts had already deemed racially discriminatory. Despite getting involved on behalf of Alabama Republicans, a year and a half later, when this case was actually decided, a different 5-4 majority nearly upheld the lower court's rulings. I'm going to emphasize how out of place this is. In law school, you learn 3 generic reasons for why the Supreme Court might choose to take a case. They have to have some way to sort through these thousands of cases they get every year, and those reasons are as follows. If a case would have national significance, if a case would resolve conflicting decisions in the appeals courts, it's called a circuit split, or if the case could have precedential value. So the court doesn't take something unless they're planning on doing something. If the court always intended to rule against Alabama and uphold the Voting Rights Act, it makes no sense that they would have taken this case. The lower courts had already properly applied the law, so why would the Supreme Court step in and force an election to be held on a map that they were planning on declaring illegal in just a few months? Clearly, this wasn't the plan. Something happened in those 6 months to shift the votes of Brett Kavanaugh and John Roberts. I'd love to tell you more about what happened, but the Supreme Court is a famously secretive institution. Well, unless you're the Wall Street Journal talking to Justice Alito, but I digress. One of the biggest problems here is that the initial order from the Supreme Court was issued on the emergency or shadow docket, which allows the court to issue substantive legal decisions without hearing any arguments from the parties or needing to write an opinion explaining their decision. So in an emergency, like having an election in the next 6 months, the court can step in and just decide what the law is without even needing to explain themselves. All they have to say is, I think the lower courts are wrong, use the old maps. And Alabama Republicans have the exact results that they wanted. This doesn't stop the court from coming back and issuing a full opinion, but they don't have to, and that matters a lot. This is discretion, or the freedom to decide what should be done in a particular situation. Discretion is a powerful political tool that can manifest as either action or inaction. Either way, a choice is being made by actors in power, and those choices mean something. The big question to come out of this case is, did the Supreme Court save the Voting Rights Act? Well, yes, if what you mean by saved the Voting Rights Act is that the court didn't completely destroy the Voting Rights Act. Is that really saving the Voting Rights Act? It's like when somebody shoves you just to yank you back by the shirt and go, whoa, I saved your life there, bro. No, you didn't. As far as I'm concerned, you don't get brownie points for being less of a dick than you originally intended to. You don't have to grade the court on a curve. They didn't end the Voting Rights Act with Milligan, but that doesn't mean they saved the Voting Rights Act, or undid any of the damage that they caused in Shelby or Bernadette. The vibes of this opinion are fucking rank because John Roberts' opinion adopts this self-congratulatory tone, proclaiming the victory of the Voting Rights Act over racism, while only doing the bare minimum to maintain the dilapidated status quo that he created. Oh, and as if to prove my fucking point, the day I'm recording this, Alabama has decided that they don't actually need to listen to the Supreme Court when they don't feel like listening to the Supreme Court. So no, John Roberts did not save the Voting Rights Act. What a stupid fucking question. God damn.
Gentlemen, we've got a caller who's been standing by. Let's let them join this conversation.
When I say the word politics, I can almost guarantee that what most of you are thinking about is either Congress or the presidency. For most Americans, the national legislature and the executive are the center of our political solar system. They are the axis everything else political orbits around. Someone who subscribes to this view of politics probably views national politics, specifically Congress and the presidency, as the only real or meaningful way to enact change. It's the burning or bust mentality of, if we don't get radical national change today, then everything is meaningless. I don't see politics this way, at least not anymore. Like I said all the way at the start of this video, this view of politics is fundamentally conservative because it offers no theory of change. Nobody has ever started a revolution by threatening to give up on politics. Real change happens when you expand your definition of politics. At the most general level, I like to think of each of the branches of government as doors or pathways to achieving your desired policy. Each and every door is different, constantly changing depending on the context, but each door is a potential pathway for political success. Take Congress, where you can pass sweeping civil rights legislation like the Voting Rights Act, but you have to convince Congress to pass that law, and get the president to sign it, and maybe Congress needs to vote again to override a veto. The Supreme Court may not be able to pass laws, but you only need to convince 5 lawyers that your position is correct. This scales down to your state and local level as well. Your mayor has different incentives and limitations in their power, even compared to your city councilor. The point is, these institutions are all pathways to political change. They just function differently and require different tools to access. Effective political actors understand this and tailor their strategies to the institutions that they are trying to influence. If Congress becomes too gridlocked to pass legislation, you shift your strategy towards the presidency and executive action. If the presidency is unfavorable, you go to the court. You get the idea. When one path to achieving your political goal is closed off or unfavorable, you shift to one that is accessible. That's exactly what conservatives have been doing for decades. They know that what they're doing is super unpopular, but they also know that they don't have to do it in public. Now, don't get me wrong, there is a lot of out-and-out fascism going on in the United States. What I'm saying is that there's a lot more subtle but equally harmful action that takes place outside of the public view. And I don't mean this is some conspiratorial thing, it's the boring stuff, like having an understaffed federal court system that pushes judges to rely more heavily on the work of advocates. Advocates that they trust, like the prosecutors and the corporate attorneys that regularly have business in their courtroom. Or maybe you trust your billionaire benefactor that has business before the court. The point is, politics is more than who the president is. It's more than Republicans versus Democrats, and it's more than just our national government. Politics is about defining our values, using power to move towards those values, and negotiating how we do that. This definitional lens allows us to see politics as something bigger, something deeper, and more complicated than the neoliberal institutions we've been conditioned to see as the only venue for politics. Of course, the presidency is political, and there's no denying that voting is a political act. But there's also a politics to what you say and do, even outside of the context of an election. This is starting to get outside the scope of this video. This is what you can call foreshadowing. But we're all engaged in politics. Everyone has values, and generally speaking, we're trying to live those values. And to me, that's the core of politics. All this other stuff, institutions, political parties, MAGA Mom Facebook groups, it's all built off of this foundation. So how does the Supreme Court figure into all of this? It's just another venue for politics. But the court doesn't do politics like Congress or the president does. I think John Roberts hates the Voting Rights Act and wants to completely destroy it. And I think that despite the fact that John Roberts has saved the Voting Rights Act twice this term. Chief Justice John Roberts found his way to the Supreme Court at a young age. A 25-year-old graduate of Harvard Law, he started his career clerking. Clerks are lawyers that help judges research and write opinions, for Justice Rehnquist. For those of you who don't know, Justice Rehnquist was an avid supporter of separate but equal, and wrote a memo arguing that integration was unconstitutional. Moreover, Rehnquist advocated for white-only political primaries and led the Arizona GOP's Operation Eagle Eye, which was created to challenge the eligibility of Democratic, aka black voters at the polls. Roberts' boss certainly had an impact on the young lawyer. According to a colleague from the time, Rehnquist reinforced John's pre-existing philosophies. John was not a believer in the courts giving rights to minorities and the downtrodden. That was the basic Rehnquist philosophy. As Roberts' term clerking for Rehnquist came to an end, another archbishop of American conservatism, Ronald Reagan, was waiting with open arms. John Roberts joined the Reagan DOJ in 1981 as a special assistant to the Attorney General. Special assistant is actually a pretty cool gig. It typically means that you've been hired to do something outside of the normal day-to-day business of the DOJ. Roberts was brought in to spearhead Reagan's radical makeover of the Department of Justice's Civil Rights Division, with a particular focus on voting rights. Instead of suing governments for violating the Voting Rights Act, the thing the Department of Justice is supposed to do, Roberts worked to dismantle the Voting Rights Act from inside. Don't believe me? Take it from him. This is an exciting time to be at the Justice Department. So much that has been taken for granted for so long is being seriously reconsidered. By 1982, Roberts had penned over 25 memos opposing amendments to the Voting Rights Act, drafted talking points for the Department of Justice and Reagan administration, ghost-written speeches and op-eds for his bosses, drafted congressional testimony, led weekly strategy sessions, and directly lobbied conservative senators. Remember this? That's John Roberts making the racist argument that the amended Voting Rights Act was nothing more than another misguided form of affirmative action, that an effects test would eventually lead to a quota system in all areas. Ah yes, the slippery slope of allowing black people to vote, leading inevitably to the end of white people. Also, does this affirmative action panic remind you of anything? Maybe relevant again? Anyways, according to the Department of Justice lawyers who worked with John Roberts, John seemed like he always had it in for the Voting Rights Act. They remember him being a zealot when it came to having fundamental suspicions about the Voting Rights Act's utility. The fact that Roberts wrote the Shelby decision makes a lot more sense when you have the context of this man's decades-long quest to kill the Voting Rights Act. I guess that begs the question, if John Roberts has it out for the Voting Rights Act, why did he save it this term? As we've said before, SAVE is doing a lot of work there, but the reason he didn't just murder the Voting Rights Act is because the politics of that would be disastrous. Right now, the Supreme Court is hanging on by the barest thread of legitimacy, and killing the Voting Rights Act would completely sever that thread. I guarantee you that John Roberts wants nothing more than to erase the Voting Rights Act in its entirety. But the thing is, writing a blockbuster opinion that blows up decades of law in favor of conservative politics isn't all that popular in 2023. John Roberts knows this, and he adapts his strategy to the moment. It's about the doors. Working for the president from within the Department of Justice, Roberts was able to be explicitly and overtly political in his stances against the Voting Rights Act. The institution encouraged and rewarded Roberts' tactics. While the 1982 amendments to the Voting Rights Act passed, the Reagan administration appointed a conservative majority to the Supreme Court, with Rehnquist taking the role of Chief Justice and John Roberts landing himself a position into the White House counsel's office. Knowing this history, you can see that Roberts made a calculated shift in the tactics when he was nominated to the Supreme Court. These hearings are where this line comes from.
I have no agenda, but I do have a commitment. If I am confirmed, I will confront every case with an open mind. I will fully and fairly analyze the legal arguments that are presented. I will be open to the considered views of my colleagues on the bench. And I will decide every case based on the record, according to the rule of law, without fear or favor, to the best of my ability. and I will remember that it's my job to call balls and strikes and not to pitch or bat.
And that's a pretty great pivot from writing op-eds about how the Voting Rights Act was anti-white racism vis-a-vis affirmative action in voting. By the time he's writing Shelby, Roberts intimately understands how to contort legal language to achieve conservative goals, while appearing neutral and moderate. Brnovich is the exact same story, just a bit sloppier since Justice Alito wrote it. But Milligan failed because it was such an outrageous case. Shelby and Brnovich had enough facts and law on their side that the conservative justices could use those and distort history, and the Voting Rights Act for that matter. Milligan just didn't have anything for the justices to work with. If they were going to blow up the Voting Rights Act using this case, it would be a clear-cut power play, and they were ready to do it. They took the case, and they sat on it for a year and a half just to uphold the lower court's ruling. Roberts and Kavanaugh pumped the brakes at the last minute because they were too afraid of owning that decision. So instead, they wrote a self-congratulatory opinion that kept the Voting Rights Act exactly where it was, comfortably under John Roberts' boot. The real message from Roberts is lie to me better. Just look at all the other aspects of the law this court chose to blow up this term. If you give the conservative justices just enough, they will move mountains and rewrite history on your behalf. They won't do all the work for you. If a conservative advocate brings a particularly bad case, the message is essentially, I would agree with you if you lied a little better next time. And the advocates get the message. Like, while I was writing this, Louisiana filed suit claiming that Section 2 of the Voting Rights Act is unconstitutional based on the court's affirmative action decision. Again, this is patently absurd, and it claims that based on an extremely wrong reading of the 14th Amendment, but that's exactly the point. This is what they want. This is the way the court does politics. They make rhetorical shifts in the law and encourage advocates to bring the types of cases that would let them do that. With our other branches of government functioning less and less, this door to political change becomes all the more appealing and influential. I don't like to end these without offering some hope for the future. I think imagining alternatives to our existing reality is the first step towards actually changing anything. That's why I want to turn to Lani Guinier. I've already told you that Lani was the first black woman to be tenured at Harvard Law, but there's a lot more that I haven't said. Did you know that in 1993 Bill Clinton nominated Guinier to lead the DOJ's Civil Rights Division? Probably not, because Clinton withdrew Guinier's nomination in less than 2 months. Why? Because Guinier was a target of cancel culture. And I don't mean that made-up stuff Meatball Ron is talking about. I'm talking about the real cancel culture, where a black woman's participation in public life is met with racist vitriol. The right-wing legal movement was shooting to kill from day one. Chris Bullock, a Reagan Department of Justice official who worked under one Clarence Thomas at the EEOC, was quick to slander Guinier in a Wall Street Journal op-ed titled, quote, Clinton's Quota Queens, end quote. If it isn't clear, quota queen is a blatantly racist label that tries to combine fears of affirmative action and racial quotas with the fear of undeserving welfare queens. This criticism, if you can call it that, was largely focused on one article. The Triumph of Tokenism, the Voting Rights Act, and the Theory of Black Electoral Success. Does that ring a bell? It's the article I relied on in part 1 to explore the underlying logic of the Voting Rights Act. This nearly 80-page article was flattened by the media into 2 words, quota queen. And that is despite the fact that Lani explicitly disavowed quota-based systems both in this article and in her public remarks. That should have mattered, but it didn't, because Clinton said and did nothing. It's better to feed Lani to the hyenas than to hear them screech any longer. Obviously, this strategy of appeasement and assimilation solves nothing. If anything, the conservative legal movement has only gained strength from our willingness to let them control the conversation. So let's set the terms of the conversation ourselves. We don't have to constrain ourselves to fit within systems that were never designed for us. One of my favorite quotes from Bell Hooks comes from The Will to Change. She says, men cannot change if there are no blueprints for change. For me, politics cannot change if there are no blueprints for change. We won't get anywhere without the courage and will to imagine a different and better future. Lonnie and Belle were friends, and they both passed away within a few months of each other. This past February, Brown University hosted a 2-day symposium honoring the lives and legacies of these two intellectual giants. I'll link to that symposium in case you are interested. I've been talking for a long time now. This script is well over 10,000 words, and I'm not sure how much longer it would be if I let myself keep writing. So I think the best way to end things is to let Lonnie speak for herself and show us what a way forward might look like. Thank you for coming on this journey with me.
My question is, well, what would equality look like? Right? Is equality simply that 50% of the Senate and 50% of the House of Representatives are women, or even more? Or do we need to really fundamentally reconceptualize our understanding of democracy itself and work within a transformed understanding of democracy to begin to then work through an idea of equality within democracy? And so that we're not just talking about what I call electocracy. Electocracy means democracy has been reduced to a single fixed moment of choice. Voters participate in democracy by going to the polls and casting a ballot. And once they do that, they discharge their responsibility. And so an electocracy means that the people have taken their power, right? It's supposed to be of the people, by the people, for the people, and I would say with the people, taken their power and discharged it or transferred it to the elected officials, to whom they then defer, as if those elected officials are the embodiment of our democracy. And so the idea is, if we elect our elected officials, if we elect our representatives, then we are a true democracy. None of those are about democracy, because democracy is when the people are engaged in collective decision-making and deliberation about the problems that affect us, and are doing so not just through voting, although of course voting is an important means of exercising power, but through what I would like to call collective efficacy, through a sense that by connecting to fellow citizens and connecting to people in their community, they are going to mobilize and organize to exercise their power to hold their elected officials accountable even after they are elected. Now this involves many shifts. It involves shifts in how we measure success. There was a young woman who said that she had been very involved in several campaigns and felt discouraged because she had lost both of them. We think if we win an election, that somehow we've won. But what have we won? That's just the beginning. Right? You need not only to hold your elected officials accountable, you need to protect them when they are being challenged. You need to play an active role throughout the political process, in other words. Who designed the game? When we think about power and power corrupting, we look at the visual competition. We look to the conflict that we can see, and we see who wins and who loses, and then what they do with their winning or their losing. But we don't necessarily go back to the level of agenda setting. Who designed the game? Okay, and then of course, the third dimension, the first is the visual conflict that you can actually observe who's winning and who's losing, and the second is the agenda setting, who's designing the rules of the game. The third is the justification that the winners give to the losers to convince the winners that they deserve to win, and most importantly, to convince the losers that they deserve their lot in life. Right? Now, it's not an accident when we're talking about democracy, especially in the United States, that our system of democracy was designed by white men who owned property. And some of that property were slaves. And they designed a system that borrowed from the monarchy that they thought they were replacing. And they designed a system in which the assumption was that elections were a means of ratifying the natural aristocracy of a community, the natural leaders of a community. So you didn't want to have competitive elections, because in some ways that was an insult to the people who were running. Elections were a means of retaining power in a particular class and giving other people a feeling that that retention of power was somehow legitimate. We have a system, the rules of the game, a winner-take-all system, in which you vote for a candidate who then gets all of the power based on getting 51% of the votes. And that person who gets elected presumably represents all of the people, including the 49% who voted against him or her. Now that's a really interesting concept. You are represented by somebody who voted against. We can focus on who's winning or losing an election, but we are missing the more fundamental point of looking back to see who's designing the rules of the game and what is their agenda. So there are all of these incentives built into the system to create a sense that our elected officials are powerful strangers to whom we must defer. And I want to suggest that we, the people, have a much more important and vigorous role to play. And if we want people to be engaged in democracy, if we want to think about democracy as a project that we all care about, then we have to go beyond electocracy and begin to look at ways in which people can participate in a much more active sense. Now, by active, I don't mean that you show up at a single city council meeting as an individual with a complaint. You will not be heard, or if you are heard, you will be dismissed, and you'll leave even more angry than when you showed up. So this is not simply telling you as an individual, go fight City Hall. It's saying we have to reconceptualize your relationship to other sources of power. And the other sources of power are not simply the person who holds formal power in your name, including the person who holds formal power in your name that you voted against, which is one of the 49%. Think about the power that you have from relationships with other people in your community. Horizontal relationships with your neighbors. Building power from the bottom up, not simply waiting for power to be delivered to them from the top down.